Ready, start. The adverse entry awarded to the petitioner has been sought to be sustained by the learned counsel representing respondent 2 that even though the adverse entry awarded to the petitioner is not in consonance with the mandate of note appended to column 1A of the circular dated 19/5/2007, but since the then district judge, Ghaziabad was the immediate superior of the petitioner and therefore, he being the reporting authority also, could have awarded adverse entry as there may be information available with him for which no material may be available. Full stop. It is in the above conspectus that much emphasis was laid to the judgment of the Supreme Court in the case of Rajendra Singh Verma within bracket supra bracket close, and it is on the basis of above that a vehement effort was made to submit that irrespective of the facts noted above, the impugned adverse entry can still be maintained. Full stop. At the first flush, the submission urged by the learned counsel for respondent 2 may appear to be attractive, but on deeper scrutiny, the same is bereft of any substance and therefore, liable to be rejected. Full stop. It is the admitted case of respondent 2 that in respect of the complaints made against petitioner, steps were taken to find out the truthfulness of the complaints made against petitioner. Full stop. As per the tabulation relied upon by learned counsel representing respondent 2, which we have already referred to in paragraph 24 of the judgment, it is evident that most of the complaints had been consigned to the record as nothing adverse was found against the petitioner. Full stop. It is also the admitted case of respondent 2 that a vigilance inquiry being Vigilance Inquiry number 6 of 2017 was directed against the petitioner in respect of the complaints made against him. Full stop. The same was converted into Departmental Inquiry number 06 of 2017. Full stop. The inquiry officer submitted his report dated 1/2/2019. Full stop. Ultimately, the inquiry proceedings initiated against the petitioner were dropped, wide order dated 21/3/2019. Full stop. Thus, the inescapable conclusion which can be drawn on the basis of above is that none of the complaints made against the petitioner was found to be true. Full stop. Once the complaints made against the petitioner were found untruthful, the very basis for awarding adverse entry to the petitioner has vanished. Full stop. It would thus be a travesty of justice to maintain the adverse entry awarded to the petitioner even when the complaints made against him were found untruthful. Full stop. In the light of above, the decision relied upon by the learned counsel for respondent 2 is clearly distinguishable and cannot be relied upon to sustain the adverse entry awarded to the petitioner. Full stop. We may at this stage, refer to the judgment of this court rendered in writ-A number 60546 of 2015, decided on 22/5/2017, relied upon by the learned counsel for petitioner. Full stop. The records which have been produced do not indicate any information gathered from any source or even the name of any person having a complaint about the integrity and judicial dispatch of the petitioner. Full stop.